Hello, everybody. This is Todd Geis from United IP Counselors. I have the pleasure, I'm here in Osaka today, and I have the pleasure of introducing Nobuharu Okazaki. He has been with the Shinjyu Global IP in Osaka for 13 years. He works with robotics, computer-related, and mechanical inventions. Today, he will be talking about case law of network-related inventions. So, take it away, Mr. Okazaki.
Okay, thank you very much. Hello, everyone. My name is Nobuharu Okazaki. I'm a patent attorney working for Shinjyu and have been working for Shinjyu for 13 years. In daily work, I draft patent applications dealing with OAs, especially in the field of controlling the traveling of autonomous robots, computer-related inventions, and mechanics, and etc. Today, I would like to talk about some important case law related to network-related inventions in Japan. The case law I will talk about may be well known for Japanese practitioners, but practitioners outside Japan may not be very familiar with this case law. That's why I chose this topic for the webinar. I hope this presentation will be valuable for you. Okay.
Oh, perfect. That should work.
Okay. Okay, outline of the presentation is here. First, I would like to explain what the network-related invention is. Then I would like to talk about the case law. After the introduction of case law, I will be law changes under discussion in Japan will be shortly explained. Then finally, I'll talk about conclusions and takeaways. What is network-related invention? Network-related invention is an invention related to a system having server and terminal connected via network. Example of the network-related invention is web-based applications. For example, video distributing system, e-commerce system, information searching system is an example of the network-related invention. Typical operation of the system is as follows. The user inputs some information, and then the server processes the information, output the results, sends the result to the terminal. The terminal displays the received result. In some systems, the server provides a program to the terminal in response to the request from the terminal. The program is executed on the terminal web browser. Then terminal executing the program performs various operations and achieves an effect of the invention. And also in some systems, a part, a typical server of the system is located outside Japan. Case law. Case law presented here is as follows. It's the first case. Presented use in the litigation is JP 6526304. It's related to comment distributing system. Patent owner of this patent is Duango. They run a video distributing service called Nico Nico Doga, like YouTube. The defendants are FC2 and HPS. FC2 also runs a video distributing service. Headquarters of FC2 is in US. HPS is a service provider using the internet in Japan. Judgment at first instance was made by Tokyo District Court. After the District Court judgment, the case went to appeal, namely the Intellectual Property High Court in Japan, and then further to the Supreme Court in Japan. In this case, the server of the accused system was located outside Japan. Actually, there's another case law related to the network-related invention, which is also important. But the explanation of this another case is omitted here to avoid confusion. The patent used in the litigation relates to a system distributing a video to the user. In the system, video and comment inputted by the user are displayed. The comments are overlaid on the video. On the video, comments move horizontally as shown in the figure, right to left. The key features of the patented system is that the position of the comments are controlled such that they do not overlap with each other. This is a claim 1 of the patent. As shown, it's very long and difficult to understand. So I show this claim 1 schematically in the next slide. In the patented system, the server receives users' comment from the terminal and transmit the video and comment information linked to the comment to the terminal. Terminal has a display control unit, a determination unit, and position adjustment unit. The terminal receives the video and comment information from the server. Determination unit of the terminal determine if the comment overlap. The position adjustment unit adjusts the positions of the comments such that they do not overlap each other. And then the display control unit displays the video and the comments such that the comments are overlaid on the system, moving horizontally and do not overlap with each other. The key features of the patented system are determination unit and the position adjustment unit. Here is the defendant accused system. The system has a server and a user terminal. In the system, the server is located outside Japan, which is US. The operations of the accused system are as follows. 1. The user terminal accesses to the server to see the video. Then the server transmits a web page for viewing, for watching a video and a program. The program is executed or installed on the user terminal. The user terminal executing the program requests the video and the comments. In response to this request, the server transmits the video and the comment to the user terminal. Then the user terminal executing program displays the video and the comments such that the comments do not overlap on the video. In the litigation, the patent owner asserted that the accused system, as shown above, falls within the technical scope of the claimed system. And transmission of the web page, the program, and the video comments from the accused server and the reception of these files by the user terminals are production of the system. Hereafter, the operation 1 and 2 are called accused operation. Why are these operations production? The logic of the assertion is that by executing the program downloaded from the server to the user terminal, the key features of the accused system are implemented in the user terminal. This implementation is the product of the system. On the other hand, defendant asserted that what is actually happened is nothing more than an ordinary website browsing. The operation of the browser are merely downloading files and referring to the files. Such operations are not production of the system. And also, according to the principle of territoriality, the patent right is effective only to act carried out within Japan. the patent right is not effective to the act where a part of the act is carried out outside Japan. Next, judgment and decision by the court will be presented. First, the district court said that the accused operations are not production defined in patent law. It means the patent right is not effective to the accused operations. Regarding the reasons of the judgment, the court said that in accordance with the principle of territoriality, in order to constitute a production defined in patent law, a product having all elements of the patented invention must be newly produced within the territory of Japan. And the accused operations construct the user terminal located in Japan and the server located outside Japan. Namely, the accused operation do not produce all elements, means both terminal and server in Japan. Therefore, the accused operations are not productions of the system. On the other hand, the IP High Court said that the accused operations are production defined in patent law. It means the patent right is effective to the accused operations. Regarding the reasoning of the judgment, the court says from perspective of appropriately protecting patent right, even if the server is located outside Japan, the accused operations should be construed as production if the operations can be construed as carried out within the territory of Japan when considering the following. A. Specific manner in which the acts are performed. B. The functions and roles played by the element located within Japan. C. The place where the effect of the invention is achieved by the use of the system. D. The impact of such use on the economic impact or interest of the patent owner. Regarding the application of the conditions presented above to the actual act, the court said that regarding a specific manner, the court said that the specific manner of the accused operations involves the transmission of files from servers located in the United States to the to the user terminal within Japan, and the reception of these by the user terminal within Japan. This transmission and reception are performed as a unified process. Then accused system is constructed when the user terminal within Japan receives these files. Taking these facts into account, it can be conceptualized that the above transmission and reception took place within Japan. Regarding B, the functions and roles played by the element located in Japan, the court says that the user terminal within Japan performs the functions that are necessary to implement the key features of the invention. Regarding C, the place where the effect of the invention is achieved by the use of the system, the court said that the accused system is accessible from within Japan via the user terminal, and the effect of the invention is achieved within Japan. Finally, regarding D, the impact of such use on the economic interest of the patent owner, the court says that such use within Japan may affect the economic benefit that the patent owner obtains. Then the court says, in view of the above, accused operation can be construed as carried out substantially within Japan, and therefore the accused operations can be construed as production defined in patent law. As presented before, the IP High Court said something about perspective of appropriately protecting patent right. In this issue, the court said that one, strict interpretation of the principle of territoriality, namely the interpretation that the act to construct a system are not production defined in patent law, just because the server is located outside Japan, would allow one to avoid the patent protection just by locating the server outside Japan and therefore hinder an adequate protection of the patent right of the network-based system. And on the other hand, interpretation that the acts are production defined in patent law only if the terminal is located within Japan is an excessively broad protection of patent right and also hinder economic activity. The decision by Supreme Court. The Supreme Court also said that the accused operations are production of the system. Regarding the reason of the decision, the court says if the act to construct the system can be recognized as production substantially within the territory of Japan, when seeing the act and the resulting system as a whole, a patent right is effective the act. The construction of the accused system by the accused operation is performed as a process to provide the defendant service in Japan and construct the accused system, including the terminal located in Japan, and coded the terminal located in Japan achieves the effect of the invention. Then, in view of the above, the accused operation and production defined in patent law. The Supreme High Court mentions about the relation between the effect and benefit and the fact that a part of the system or act is located outside Japan. The court says in relation to achieving the effect of the invention, the fact that the server is located outside Japan does not have particular significance. And B, on the other hand, in relation to the ownership of the patent right, there's no circumstances that the accused operations and the accused system do not have any economic impact on the patent owner. Law change. Since the decision has been made by the Supreme Court, changing patent law is now under discussion in Japan. Patent law change will be to clarify the conditions to define acts carried out substantially within Japan. The conditions are as follows. A, the effect of the patented invention is achieved within Japan. B, if the economic impact on patent owner materializes within Japan. C, if a part or element of the patented invention is embodied within Japan. Conclusions. In conclusions, infringement related to network-related invention. One, the operations to construct a system should be construed as production of the system carried out substantially within Japan. To consider the operations as production carried out substantially within Japan, the effect of the invention achieved by the device located in Japan is important. Takeaways. Here, some tips for patent application drafting for the network-related invention are presented. In claim drafting, for broader protection of your invention, recite as many categories of claims as possible. For example, you can make a system claim, server claim, terminal or device claim, and method claim, and program claims. And some Japanese practitioners suggest a method of producing a system in view of the proposed categories. Of these categories, in view of the proposed law changes, system credits may be of more importance than other categories. It means that the system claim is must in the application. According to the proposed law changes, it is required that the claim should include an element located within Japan. In order to satisfy this requirement, a claim should include both a server located outside Japan and a terminal located within Japan. Regarding the specification, it is important to describe the effects achieved by the terminal in addition to the effects achieved by the system and the server. This is because in most cases, like the case law, the terminal is located within Japan and the terminal achieves the effect of the invention. Here, consider one example. In the case law, all key features were implemented in the terminal device by executing the program downloaded from the server as shown in left side figure. In this case, it will be easy to discuss the technical effect achieved by the terminal because all the key features are in the terminal device. On the other hand, what about the case where all of the key features are implemented in the server as shown in right side figure? In this example case, the server adjusts the position information of the comments and the terminal displays the comments based on the position information. Thus, the terminal can display the comments such that the comments do not overlap with each other. In this case, the contribution of the terminal to the effect of the invention is small, because the terminal only has a functionality of displaying the video and the comments based on the position information. In such a case, you may feel it is difficult to describe the effect of the terminal because the contribution of the terminal to the effect of the invention is small. In such a situation, it is recommended to consider the influence of the effect achieved by the server to the terminal. In the example case, the server adjusts the position information and the terminal displays the comments based on the adjusted position information. Thus, the terminal can display the comments such that the comments do not overlap with each other. This operation shows the influence of the effect of the server to the terminal. Therefore, you can emphasize this operation in both a claim and a specification. For example, a system claim for this example case can be recited as follows. A system for distributing a video and comments overlaid on the video and moving horizontally, comprising a server configured to adjust position information of the comment such that the comments do not overlap with each other, and the terminal configured to display the video and the comments based on the adjusted position information. As shown, the system claim recites that the server adjusts the position information and the terminal displays the comment based on the adjusted position information to make clear the influence of the effect of the server to the terminal. Then, in the specification, you can describe the effect of the invention as follows. Since the terminal displays the comments based on the position information adjusted such that the comments do not overlap with each other. The terminal can display the comment overlaid on the video and moving horizontally such that the comments do not overlap with each other. The first part of this description describes the influence or the effect of the serverless terminal. Thank you for listening. If you have any questions and comments, please contact me with this email. Thank you again.
Thank you so much for that presentation, Mr. Okazaki. As someone who is a patent agent in the United States, the principle of territoriality, I found that very interesting. I had never heard that before. And especially as someone who has handled a lot of mechanical cases, we just think it doesn't matter where these things are produced as long as they're brought into the United States. So I do have a question. How does that work in a mechanical case? If parts are produced outside the country of Japan and they're brought here, how does the principle of territoriality work?
It's a difficult question and also question. Well, I'm not sure, but in my opinion, maybe it's a well, it's yeah,
take your time. He can always edit things, so don't worry.
It's okay. Maybe. So you said it's some mechanical products are made in US and
A foreign country outside of Japan. Just because parts are outside of the country, that's not a concern usually. But I guess in this system, it is a concern.
Yes.
Yeah.
Yes. I think regarding the system invention, it's easy to move the functionality to outside Japan or inside Japan.
Yes.
And that is a problem. Yeah. In this case law and generally for system invention, I think.
Right, but not so for mechanical.
Not sure.
That's okay.
It's difficult to say.
Okay. No worries. No worries. No worries.
I'll think about it and
okay.
I'll have some answer to that. Yes.
Okay, sounds good. Sounds good. That was great. That was great. Again, thank you so much, and great job.
Okay, thank you very much.
Yeah.